Israel has, in the main, maintained, of course, its right to defend itself against Hamas and has asked the ICJ to reject South Africa's case and its requests for emergency measures. South Africa has extensively argued yesterday, as you would know, that Israel violated the 1948 Genocide Convention. South Africa will be hosting a media briefing, we're told, at around 3 p.m. this afternoon, just to respond to what we have seen over the past few hours as Israel was presenting its case. We'll also get further analysis in terms of what transpired and what Israel's case was in the main in a few moments' time. Of course, just to sum up some of the last few speakers that we've seen, Israel's Deputy Attorney General there saying that South Africa has failed to show that provisional measures should be put in place to protect Palestinians in Gaza from harm. And of course, a little bit earlier on, Israel's Deputy Attorney saying that listing, in fact, a couple of reasons why South Africa has failed to make the case for provisional measures. The applicant has not shown any dispute between Israel and South Africa and has tried to mislead the court into thinking its existence. And of course, the applicant failed to meet the conditions of plausible right to be protected in the current circumstances. Of course, we'll unpack what all of this means. The court will be deliberating, particularly in terms of the interim measures, and they are likely to give a verdict, whether for or against South Africa, in a few days or in a couple of weeks, we are told. But the case, in terms of the merit of the case, that will take weeks, months, or even years, we are told by some experts. But let's now get analysis. We are now joined via Teams by Dr Kingsley Makhubela. He's the former ambassador and director of Risk Recon. And of course, he joins us now. Thank you so much, sir, for your time this afternoon. So let's unpack then, what we've just seen. I mean, yesterday, South Africa contended before the ICJ that Israel has violated the Genocide Convention of 1948. And also, asked the court to consider interim measures to stop Israel's attack on Gaza, amongst others. Before today, there was a lot of speculation in terms of what Israel's rebuttal would be. So we heard, firstly from Professor Shaw, for Israel, saying that the 7 October attacks on Israel by Hamas constituted the true context for South Africa's allegations of genocide against Israel. So do you think perhaps, those comments that we saw earlier essentially then set the bar and the base for Israel's argument that it was, in fact, Israel who is the true victims of a genocide here?
Good afternoon. The biggest gun the Israelis brought to this hearing was the Deputy Attorney General. And some of the things that he said are undisputed. For instance, the level of the independence of the Israeli judiciary system, it's factual what he said. But he also brought into the court measures that they are undertaking in terms of what he calls irresponsible comments made in the process, and that they are in the process of looking into those and to prosecute them. And really to rebut that these individuals who may have uttered the statement, they don't reflect the opinion of the State of Israel. And the Attorney General is looking into that. So that was too strong. And you would have seen even during the presentation, this question of utterances that South Africa presented yesterday that are sending messages to the soldiers have been attacked as not reflecting the views of the Israeli government. So these are some of the very strong points that came out during this sitting. And really, the request for South Africa for interim measures, they really dissected them and attacked them one by one. It remains to be seen if the court will be swayed by what Israel presented today or what South Africa presented yesterday. It remains to be seen. But I must confess that what I've seen today presented by Israel they really came out with very strong evidence that I don't think anyone needs to take this for granted, need to look at this very seriously. The decision may go either way.
Did you mean to say very strong statements or evidence? Let me just get that clear, Dr. Makhubela, in terms of evidence. Because, I mean, if you were listening to South Africa yesterday, Advocate Nkaidobi, and I mean, his part of his statements was crucial to the case, right? It spoke about the intent of genocide. He asked the court yesterday that, you know, any suggestions, you know, by Israel, you know, officials that they did not mean what they said should be rejected by the court. I mean, what do you then make about Israel's comments in as far as that is concerned? I mean, when we look at Advocate Shaw saying South Africa has basically taken random quotes that are not in any conformity with policy, calling the arguments as misleading, when in fact Advocate Nkaidobi was at pains to bring that evidence in court by you know, show of video footage, also utterances that were made publicly by senior officials of the Israeli government.
There's no interrogation of evidence at this stage. It's to really provide what the court calls prima facie argument to show there's some level of intent to commit genocide. So there's no one who presented evidence at this stage that will be interrogated. That's the starting point. But what I'm saying is that the argument that Israel presented today to rebut what South Africa presented yesterday, it's quite strong. Israel, in many instances, accepts the fact that, for instance, people may have issued other statements, and they are saying, that's not the policy of government. There's a total different chain of command that implements that. There are different systems. And the Attorney General then came up to say, listen, we are actually in the process of investigating this kind of statements. We are in the process of investigating even those who may have gone beyond what the IDF wants in terms of their operational duties. So these are issues that we are that South Africa has made a request that this provisional request that whilst they are looking into the merit of the case, it's better to prevent this genocide being carried on continuously. So I'm saying there are compelling reasons that were presented today that the court will need to go through them. And I'm saying it's not an easy one, given what I've been listening and that everyone has been listening. And I'm saying the biggest thing was for Israel to bring the Deputy Attorney General, given the fact that all of us, we know the level of independence the judiciary and the prosecution authority enjoys in Israel. I mean, this is the only country where they take the sitting prime minister, it doesn't even need to be impeached, and they charge him. So that you can see the level of independence in terms of the judiciary in Israel is quite strong. But what they presented today, it still needs to be really subjected to interrogation by the judges. They would have to look at both cases. What I'm saying is that it's not a walk in the park. There's evidence that has been presented today. I mean, Israel has given, and I think they have done this quite deliberately. They've given the assurance that, quoting the Prime Minister's statement, that they are making arrangements. They've set up systems and processes for the return of people who are displaced in Gaza. It really undermines the argument that, because in the definition of genocide, there must be a deliberate intention to really displace, remove people from their own land and to kill people because of their own identity. So that it's been rebutted. The court will then say there are measures that are in place. Will the court accept this, or they will accept this as a ploy really to try to overcome this? And I think Netanyahu was quite smart in the last 3 days to come up with a statement. Remember, Netanyahu has been refusing that the post-Gaza conflict, Israel would have to control it. And 3 days ago, he came up with a statement, which I think from where I'm sitting was intended actually to show the court that this is not our intention. There's no genocide, you know. So these are not easy questions, I must say.
And let's continue then to talk about the interim measures, because at least we know that finding by the court will happen in the next couple of days, 2 weeks, we are told. Let's continue to look at what was said then today. I mean, in the form of the response to South Africa's application, Israel, of course, talking about self-defense, the right to defend itself. The Israeli team says, their action was necessary and was consistent with international law, and that it does, in fact, have a right to defend itself. Of course, there have been questions, some experts saying, yes, but that does not necessarily apply to international law, where we are talking about an area that you are occupying, which is within your jurisdiction, which is Gaza. And then when you look at yesterday, South Africa, said Israel's actions were beyond self-defense. So in other words, it agreed on the right of self-defense, but not to the extent that we have seen, not to the extent of over 23,000 people, most of them children and women, having died, and the extent of the damages in terms of healthcare services. Just given these statements that Israel has made before and today, does it then compel the court to order Israel as a provisional measure, at least, given that parts of this also are contained in the UN Charter, to allow for some of these measures to then be implemented?
It will be very difficult for really anyone to be convinced that the killing of children and women and elderly and the attack of hospitals must be attributed to Hamas, as Israel insinuated in this presentation. I think that's going to be very difficult for anyone to be convinced about that, because this conflict has been playing itself in the social media, in the media space, and everyone could see that, and the responses that were made by senior Israeli officials were quite clear. I think there are issues that Israel will be found wanting, no doubt about it. That's one of the things. But I think one thing that I think South Africa should have really reinforced its presentation at this hearing was to bring in an expert in terms of military conflict or military lawyers who can really provide a strong argument. You'd have seen the Israelis, they came up with somebody who's probably an expert in military law, who really presented the behavior of IDF, the principle, went into the strategy and tactics of Hamas, unpacked it, and literally put it in terms of their own position. What are the challenges around this? So we did not present a very strong argument. I'm talking about South Africa yesterday in terms of the military nature of the operation, how indiscriminate it has been, and so on. So that we did not. And I think in retrospect, we should have beefed up that part of the presentation. But there are things that Israel would find it very difficult, I must say, really to convince anyone. No one has been charged, as the Attorney General said, or no one has been taken into military court about their behavior and so on. Having said that, you remember when one minister said in Israel that they would better put a nuclear bomb to really destroy the entire Gaza. The Prime Minister came in and really suspended that minister. And that was the argument that was made today, to say where there has been people going out of what they're supposed to do, this is the action that has been taken. Will that convince the bench or the court to say there were measures that were taken against politicians? It remains to be seen. Are there actions that have been taken against soldiers, what South Africa presented yesterday, celebrating the killing? It remains to be seen if the court will be convinced by this. But what I'm trying to say is that looking at the evidence that has been presented yesterday and today, it's not going to be an easy task as people thought initially. And the question of the jurisdiction has been the fundamental argument of the Israelis, challenging the jurisdiction of the court really to listen to this matter. And they've made their own argument in terms that, are the argument persuasive to the bench? It remains to be seen.
And just on that point about evidence and questioning, South Africa's, strong points. In fact, one of the Israeli attorneys today, Galit Aragwan, I believe her name was, questioning South Africa's use of evidence and facts, saying that at best South Africa is unfamiliar with facts and at worst, South Africa deliberately perpetuated a false narrative. I want us to just hone in on that last statement, the latter part of that. Why would South Africa, why would it be, in fact, in its best interest as South Africa to have an agenda? And of course, we know that jurisdiction was also something that came out quite strongly from both parties. Just talk to us about, those comments that were made today.
You would have seen during this presentation, it was interwoven in almost all the legal team and so on. The idea that South Africa has no proper knowledge about what's going on there, that is far from the situation. It was overtly or covertly indicated during the process. And that it's intended to say, because you are so far away, you are not aware about the details. And that's why you would have seen in certain instances, Israel will bring in the name of Saudi Arabia, that we're working together to do this. And I think that's where the weaknesses, again, of the South African presentation is. And one has been saying this. It would have been better if countries around the region were part of this, because they could rebut that. Because what was said also that at one stage, the arrangement between Israel and Jordan to fly in helicopters with aid and so on. And they were insinuating, of course, that Jordan understood the dynamics in the situation. They are on the ground. They are directly affected. And it keeps on coming up. And that was essentially to indicate that South Africa may be ignorant about the dynamics in the situation that is unfolding in that part of the world.
Dr. Makhubela, I'm not sure how much you've heard, there from my colleague in terms of just his comments. He mentioned, of course, something that transpired in court today where the Israelis were at pains to say that South Africa did not adequately address, atrocities that were committed by Hamas on the 7th of October. We, of course, heard from the South African government, not only in their submission, the 84-page document, but also from the, the Minister of Justice later on. And in fact, during their submission yesterday, that indeed, South Africa has condemned that action that occurred on the 7th of October. And in fact, a note verbal was sent to the Israeli Prime Minister, in response to that attack. What more could South Africa have done in as far as that is concerned? And what do we read into that in terms of what Israel is saying?
Well, Israel's strategy here was not to respond word by word about what South Africa presented, was to put their own case in terms of the atrocities of Hamas. But the South African legal team was at pain yesterday to indicate that this court hearing is not about Hamas. There will be a total different platform to hold Hamas accountable to its behavior or the atrocities it committed. This is about the state of Israel. So that was the focus of the discussion. Of course, for Israel to want to draw the parallel and say Hamas is not here, we're the only ones who are here, that was not the intention of this hearing. That's why Israel missed the point.
In terms of, just the next steps, particularly because there are two processes to this case, we understand that. But just in terms of the interim measures that the court has now got to look into, what are the consequences should, the result be against South Africa? And by consequences, I'm talking about what is currently happening on the ground in as far as Gaza is concerned. The humanitarian crisis, we are told, is actually at a worse stage than it was. And these are aid agencies who are telling us this. This is not quotes that have been thrown around as per the statements that we heard earlier in terms of South Africa's argument.
The Israelis' strategy throughout this hearing has been to try to project this as a problem of humanitarian challenges that they are facing for providing as the occupying force. Because as the occupying power, they have the responsibility, as South Africa indicated yesterday, to provide water and basic services. So they've been at pain to really frame this as a challenge around international humanitarian law, which has nothing to do with genocide. And it brings in again the question of jurisdiction, because once you start to have a big focus around international humanitarian law, you are then saying this court, it's not competent to listen to that matter. And you put in this idea to the court that this belongs somewhere else without saying that. That's what they are saying. That's what they've been at pain to indicate. I mean, throughout the presentation of Israel, the reference it's made to the challenges of providing humanitarian assistance, not by Israelis, even by other countries that are bring numbers of how many liters of fuel and gas it's moving in as part of their humanitarian effort under the obligation that they have with respect to international humanitarian law. So that has been the biggest framing of this argument, to take it away from the convention that deals with a genocide and say whatever shortcomings that are there are the shortcomings that are presented by the nature of the conflict, the urban conflict they are faced with. That's how they're trying to frame this thing. But as the occupying power, they never even made any explanation about the indiscriminate attacks that we've seen. They did at the end to say we're scaling down, and we know that they've started to remove some of their major brigades from there. And they are going into what everyone has been saying. The Americans have been advising them to go into what they call surgical attacks and precise attacks that would not affect everyone. Why didn't they do that right at the beginning? This will be the question. Why are they doing at the end once 23,000 people have been killed? So there are challenges in terms of their presentation that they'll find it very difficult to convince the court. But it remains to be seen if the court will be persuaded by the arguments made yesterday and today.
All right, Dr. Kingsley Makhubela, thank you so much for your time this afternoon. Really do appreciate it. Of course, those were comments made by Dr. Makhubela, former ambassador and director of Risk Recon.